Actually, I have no problem in coming to the court. I will come, but I see your ladyship has got highlighting of submissions and another pattern, but I'll be there in the next day. Then I cancel it is not even a part in this matter. Sorry, let us be as you directed. Hold your horses.
HCC E004-2022, Lampard Luanga Omboti versus Office of
For the intended sixth plaintiff, they have made an application. I do not know whether the intended interested party, Tuma is the party. Is Mr. Munzala, M-U-N, Z-E-L-A, Ms. Nasilim, and Ms. Nasilim, for the intended interested party, Mumias Outgrowers. Sorry,
that is John Pesa Omuyonga, Gilbert Omore, Opala Wycliffe,
Mr. Joel Omari, for which party?
I stand for the fifth respondent, the Competition Authority of Kenya.
You've got the plaintiff's application the 20th of January. That should be for directions, I believe. Although I think we can actually hear it together with the first application, but we'll come to that. You've got, it seems to me you want to say that we can move along. You were persuaded on the 14th of January that the application of the 11th of January is urgent. You said urgent for hearing, and fix it for hearing today.
Yes.
And give direction to institute the suit. The other applications, in my humble view, the parties, if they wish, if you allow them, can address the court. But it seems to me that we must use judicial resources as well. We should be having the application, which we give very strict timelines on. On the part of the first and second defendants, we are ready to proceed.
Melody is speaking for the plaintiffs, Kibe Mungai. The directions given on 14th of January for purposes in this sense, Melody. The respondents were given 4 days to file and serve their respective responses. We admit that there was compliance by the first and second defendants in terms of filing of the responses. The third and served their responses alongside submissions this morning.
Good afternoon once again. Or is this evening already? So this is my short ruling that I've managed to craft in the short time that was available to me. So when this matter came up for directions on 14th of January this year, the court issued full directions regarding the inter partes hearing of the application dated 11th January. The court also issued interim orders in terms of prayers number 3 to 7 of the said application in order to preserve the subject matter of the application for 10 days pending inter partes hearing slated for today, the court also expressed its desire to hear and determine the application expeditiously, owing to the urgency expressed by the parties and the public interest generated over the subject matter in question, being the leasing of Mumias Sugar Company. When the matter came up for hearing today, Mr. Kiragu Kimani, learned counsel for the first and second respondents, noted that there are at least 5 types of applications in the court record, and he listed them. I do not need to go through them. Mr. Kibe Mungai, counsel for the plaintiffs, informed the court that some of the respondents, except the first and second respondent, did not fully comply with the timelines given in the directions of 14th January 2022 and had either not served them with their responses or filed the same late this morning. Mr. Kibe indicated that he will require at least 3 days to peruse the said responses, especially the response by the 6th respondent, so as to make a rejoinder thereto by way of a further affidavit. Mr. Muite, senior counsel, submitted that he had instructions to appear and apply for the joinder of a 6th plaintiff who he stated has a similar cause of action against the respondents. Counsel indicated that his clients craved to be heard in the application dated 11th January. Mr. Orengo, senior counsel, urged the court not to consider any other application, especially for joinder, as the respondents have not had time to respond to them. He urged the court to proceed and hear the application that is coming up for hearing. Mr. Dunstan Omari, for the intended 10th defendants, submitted that parties should be given time to argue their applications from the bar without filing any responses, since that is the precedent that has been set by this court in the proceedings of 14th January. Counsel urged the court to proceed and hear the application dated 11th January, as it affects the whole country. Mr. Munzala, counsel for Tumas and Tumas, an intended interested party, informed the court that his client's application for joinder dated 18th January was not opposed. He urged the court to allow it as prayed. Mr. Odero, advocate for the intended interested parties, who he mentioned to be farmers, informed the court that his documents were yet to be uploaded in the e-filing portal. He urged the court to grant his clients the opportunity to be heard. Ms. Odek, learned counsel for MOCO, Mumias Outgrowers Company, a creditor of Mumias Sugar Company, also indicated that her clients had filed an application to be enjoined in the suit, as its final determination will directly impact on them. Mr. Gishaba, learned counsel for the 6th respondent, was of the view that the matter listed for hearing is application dated 11th January and that the court should proceed with the hearing, even as it gives directions on the rest of the applications. Counsel indicated that he was ready to proceed with the application. Mr. Bett, for the 3rd, 4th, and 7th respondents, was not opposed to Mr. Kibe's request for time to file his further affidavit in response to the documents served on him. On joinder of parties, counsel submitted that it will be prudent that the respondents be granted time to respond to the joinder applications before any orders can be given concerning the joinder. Mr. Omari Joel, advocate for the 5th respondent, submitted that he is ready to proceed with the application dated 11th of January. He, however, indicated that he had not been served with the joint applications. I have considered the rival positions taken by parties herein regarding the directions or step that the court should take today in dealing with the application dated 11th of January. That is ideally the application that was listed for hearing and the subsequent applications that were filed after 14th of January, especially the applications for joinder of various parties, either as plaintiffs or interested parties. On the one hand, there are parties, especially the respondents, who opine that the court should go ahead and hear the application dated 1st January, as it is the matter scheduled for hearing, while on the other hand, there are new entrants in the matter who not only seek to be enjoined in the proceedings, but also seek to participate in the application that is the subject of today's hearing. Mr. Kibe Mungai, for the plaintiffs, intimated to court that he needed time to respond to the replying affidavits that were served on him today outside the timelines. I note that the sixth respondent did not deny that it filed and served its response on the plaintiff's counsel this morning. I find that in all fairness, and considering the fact that the court had on 14th January issued clear directions allowing the applicants to file and serve further affidavit within 3 days from the date of service with the replying affidavit, Mr. Kibe has made out a case for the granting of the 3 days sought to enable him file his further affidavit. Turning to the question of whether the joinder applications ought to be considered, the court notes that the intended interested parties and plaintiffs have indicated that they have an interest in the subject matter of the dispute before the court and seek to be heard on the same. The right to access justice and be heard before a court of law on any dispute is a constitutional right which this court cannot overlook or deny any party. In the circumstances of this case, and considering the public interest that the case has generated, it would be naive, if not foolhardy, for this court to ignore the pleas that have been made by the intended new parties to the case and proceed to hear the application, which they have stated they have an interest in. A different position would mean that the court will be hearing parties piecemeal or at different stages, which in my view will be a counterproductive approach that will have the effect of clogging the court with numerous applications and cases, thus negating the very reason why the court gave parties an early hearing date, which is to expedite the matter. So having regard to the findings and observations that I've made herein, I issue the following directions. Number one, the plaintiffs are granted 3 days from today's date to file and serve the further affidavits. Number two, the intended interested parties and plaintiffs are to immediately serve their respective applications together with skeleton submissions on the plaintiffs and the respondents, who will then have 3 days to file and serve their respective responses and skeleton submissions. So the court will list the joinder application for hearing on a date that I will give you right away. And I think at this juncture, it is prudent for me to indicate to the parties that this court will not be sitting from 1st of February to March. I will be on leave council. So
What we are pleading for your leadership is there.
The 3rd, 4th, and 7th respondents have dated their submissions. I can confirm that I was following closely. I inquired specifically to Mr. Alan Kamau yesterday about whether we are still to expect their responses. By 5 p.m., those responses have not been emailed to us, and they have case, but I believe they will speak for themselves.
So, just as you go through the preliminaries,
Yes.
by the call,
Yes.
I just wanted to notify you that the court still has another matter coming up for hearing,
Yes.
which is equally very urgent.
Yes.
So the council in that matter.
The Competition Authority, I believe we received their documents on Friday. Sarrai Group Limited, they initially filed grounds of opposition. The 5th defendant respondent, who had filed their documents within the time indicated. All those responses that came late by the rest of the parties, we have obviously even that filed, we were served this morning. Actually, we got it from the portal, but I confirmed with Mr. Gishaba and confirmed to me at about 8:50. They sent the email. Have not completed answering the responses received because of the urgency of the matter. That was the original direction, and you are willing to comply with it. Whether it's hard. But I leave the court to address itself on that issue.
I seek the directions of this Honorable Court. Our application for JOIDA as a plaintiff, sixth plaintiff, was filed under certificate and it had been served. I plead to place the following few matters on record. One, the intended sixth plaintiff, in seeking to be enjoined in the current proceedings, had in mind saving judicial time, for the reason that the courses of action it has, the complaints it has, are similar, some identical, to the complaints raised in these proceedings. And therefore, filing separate proceedings would not only have clustered the court diary, but would have compromised on judicial time. It's much neater for the parties with similar causes of action arising from the same transaction to be heard in the same proceedings. So that should be considered by this honorable court.
You have served your application?
Yes, it has been served. And we even have affidavits of service. The second issue I want to mention very briefly is that West Kenya Sugar Company Limited was the highest bidder at 36 billion Kenya shillings compared to Sarrai Group, which bid at under 6 billion shillings, 5.8, a difference of 30.2 billion shillings, which, if we are enjoined, we will be seeking to get an explanation on from the receiver manager and from Kenya Commercial Bank. So I plead that because we would want to be heard on the application coming up for hearing today, that was coming up for hearing today, on the plaint itself, because West Kenya Sugar Company Limited wishes to have the opportunity to be heard going forward in these proceedings, our application for JOIDA be considered at this early stage, because that will inform the way forward. I thank you.
11th January 2020, without the benefit of the respondents or defendants filing responses. And orders were made in those circumstances, despite the fact that there were notices relating to the jurisdiction of the court. Now, lady, I'm saying this because I am pleading with the court not be attracted to consider any other application in the same way, particularly for joinder, when we have had no time from the time of service to respond to those applications. And with respect to the remarks made by Senior Counsel Mr. Mwite, the issues about whether the highest bidders or not, we should be given an opportunity to make those responses. Because it would demand they did not qualify. But that would be getting into that application if we don't want to. My lady, then
Senior Counsel, you said you need time to respond to the applications for joinder.
For joinder.
How much time?
at least 3 or 4 days. Because, my lady, we are having a multiplicity of suits. Some of them which have been determined, some of them which are ongoing, and all these matters need to be placed before your lordships to determine whether West Kenya and others have a reasonable stake or a locus to be had. Because in our submissions, we think some of them were just busy bodies. My lady, therefore, before you can consider any other application, I plead with the court to proceed what the court directed should happen today at 11 or thereafter, because the court explained that your list is long and we are likely to be had after 11, after the court had cleared the other matters in the false list. So I'm pleading with the court that under the circumstances in which the orders were given on the 14th, it is important that the directions of the court, insofar as hearing the applications are concerned, is proceeded with as directed by the court. As far as the matters, some matters which my learned friend Mr. Kibe has mentioned about compliance, I think we can address you adequately on that question if the court determines that we're dealing with those particular applications.
The position taken by Senior Counsel Orengo and Kiragu that have not filed their submissions or their responses. Arguments proceeded and orders issued. And as Gakwamba, a lady will be seeking that the same applies today. Any party that has not filed and served be given a time to argue from the bar as previously done. 2, among the critical issues raised by our client, that the original plaintiffs have no locus. The new applications of West Kenya and other parties want to cure that fatal blow by now having the real complainant, West Kenya, in court, who has been litigating by DC bodies. We are seeking that.
My lady, I have to object to that. That is disrespectful. Particular hearing is yet to be established. Who is not a party? Let a defendant, his application is pending, just like West Kenya. So he has to withdraw that. Those are things he says on national television, which are some duties. And I think the dignity of the court should be respected. But it is Omari trying to respect other counsel and the parties who are before the court. I have clients who have signed all the documentation and they have described who we are. If we have a problem with their letters, we join the case first.
Forward. Lady, I appreciate and apologize. Save that when Senior Counsel Orengo uses this body, it really does not hurt. Doesn't hurt with a Kibet, but we are applying together with Kibet to be senior counsels next time. Off the cuff, my lady, what we are saying is that let it flow from the same pot as it flew. Let this matter proceed inter parties. The whole country is glued to this matter. Is a whole matter that affects almost 90% of the Kenyan budget. It cannot wait. We need Bakwamba's application. Thank you very much, my lady.
My lady, addressing this court on behalf of Mumias Limited, proposed interested party. The same was served on the 19th. We have an affidavit of service dated even date. And the date is
My lady, I've had the application and the suggestions and opinions that have been made specifically on the continuation goes, either if the tender is awarded to or the person who had 6 billion or 5 billion. And my lady, it is important that before the fate of my clients are decided by the application that is currently before you, they be given a chance to also participate in the same as the final consumers of the judgment that will be given by this court in whichever direction that happens. So my lady, I appreciate the urgency of the matter, monetary-wise, but in terms of the final effect, my lady, I say that this is one of the matters where the court needs not to lock anyone outside when they actually have a chance to put their voice across. That's all, my lady.
MOCO, Mumias Outgrowers Company Limited, who have filed an application for joinder as a 7th plaintiff. We also seek that we be allowed to participate in these proceedings. The course of action is similar to the one raised by the complainants in these proceedings. My ladyship, it would not be right to waste judicial time by filing similar cases when the cause can be heard in the proceedings that is before court. Your ladyship, MOCO is owed more than 3.7 billion by Mumias Sugar Company. It seeks to know how this debt will be paid to it. MOCO would want to participate going forward in this case as the final outcome of the case would affect its interest. We pray that our application for joinder dated 24th of January
this year, that is the application coming up for hearing today.
the rest of the applications are for directions. As submitted by my learned colleagues, there is a reason why the application that came before you on 14th of January, which this court ascertained and proceeded to issue orders that we had today. We are saying we are ready to proceed with the application today, despite my senior learned colleague, Mr. Kipe's submission that he had not been served with the responses. And therefore, by innuendo, that he has not filed it.
Pursuant to the court orders of 14th January 2022. My lady, on the part of the third, the fourth, and the seventh defendants, we filed our grounds of opposition. We served all parties, including Mr. Kibe, yesterday, since we had difficulties with our e-citizen or e-filing portal. However, we managed to serve Mr. Kibe yesterday together with all the other parties. My lady, in the circumstances, and pursuant to Mr. Kibe's request that he needs time to go through all the documents that have been served on him, we are not opposed to the service. Court can grant Mr. Kibe the time to go through the documents that have been served on him and to file any responses. My lady, the part of the applications by the interested parties and the intended plaintiff, we are all in agreement that those applications were not coming up for hearing today. Therefore, no interim or substantive orders can be issued on those applications. My lady, there are quite a number of interested parties who have filed their application, and with the kind of heat that this matter has generated, we expect more parties to file their applications. But for the parties that have already filed their applications, Your Honor, I believe that it is prudent that we be given an opportunity to have a look at those applications. Should need be, we be given an opportunity to respond to those applications before court makes a determination whether to join the interested parties as well as the interested plaintiff. Should they meet the criteria set by superior courts and even these courts on the threshold that an interested party should meet. My lady, on the same ground, we do not expect that this court issues any orders as to join any party until parties file their responses, if need be. That is all.
Remind me of your name, Council.
My name is Omari Joel. Yes, in our response, we just want to confirm that we filed our reply to the application dated 11th of January, as you had directed on 14th of January. and we were ready to proceed today. So we just want to restrict ourselves to the litigation related level. With respect to the applications that have been filed for joinder, both as parties and respondents, we haven't been served, therefore we really are not in a position to take a substantial position on those applications. We will try applications and put in our response.
I've asked my court assistant to just upload them and avail them to me. So then I will take some time to consider your submissions and give you a way forward before the close of the day, say by 4:30, if Mr. Type G, and we have another hearing to take.
It's at 4 p.m.?
4:30.
4:30.
Yes.
We come back physically?
Yes.
Yes. Yes.
Yes, if you can come physically.
Physically
okay.
is better.
We're much obliged. And perhaps the only thing I have the question for the issue is that if you are going to be inclined to grant an adjournment and to consider the question of the order, we would like to be.
When you get there.
I just,
But Your Honor, it is
would not
a very
confronted with an order.
The issue of that order is very critical.
It's lapsed.
Yeah.
Just
Much obliged.
Okay. 4:30, Mr.
4:30. Senior counsel.
How are you, my son?
It was very hot outside. And you are making it hot.
We are still in court.